Today, we're diving into a classic neighborhood showdown. One homeowner taking on their HOA. It's a fascinating story that really hinges on how you interpret just a couple of words in a legal document.
So, picture this. You ask your HOA for some specific financial records, and they basically come back and say, "Sorry, we don't have them." Is that it? Is that the end of the line? Well, for one homeowner in Arizona, that was just the beginning of the fight. All right, let's set the stage. This whole thing kicked off with what seems like a pretty straightforward request for information.
So, our homeowner, a guy named Mangus MacLeod, wanted to get a look at the nitty-gritty details of some of his HOA's investments from a couple of years back. He specifically asked for the history trail for 4 certificates of deposit, CDs, that were held by his HOA, the Mogollon Airpark Association.
Now, the Airpark Association, they got the request. They and their management company gathered up all the records they had on hand. They even called their banks to try and get more info, and they sent Mr. MacLeod everything they could find. As far as they were concerned, they'd done their job. But for Mr. MacLeod, the records just weren't complete, and this thing was far from over.
And this is where we get to the real core of the disagreement. See, it wasn't about whether these records existed somewhere out there. It was about whose job it was to actually go out and find them.
This whole legal fight really boils down to 2 totally different ideas. On one side, you have Mr. MacLeod, who was convinced the law meant the HOA had to actively go get any records he asked for, even if that meant chasing them down from a bank. On the other side, the Airpark argued that no, the law just required them to open their files and give him whatever they already had. 2 very, very different takes on the exact same rule. And here it is. This is the exact phrase that the entire case hangs on. Arizona law says records shall be made reasonably available. So, the multi-million-dollar question is, what does make available actually mean? Does it just mean handing over what's in your filing cabinet? Or does it mean you have a legal duty to go hunt down documents you don't even have? The judge's answer to that question would decide everything.
So, with both sides completely dug in, this whole thing blew up from a few emails into a formal legal petition. Let's trace how we got from point A to point B.
So the first request goes out in April. By June, Mr. MacLeod isn't satisfied and he files his petition. Now, what's really interesting is that in that same month, the HOA president actually went with Mr. MacLeod to a few banks to try and help him get the records himself. But by that point, the legal gears were already grinding, and it all led to a formal hearing that fall.
Okay, before we get to the big verdict, we gotta talk about this key legal idea. In a civil case like this, the burden of proof was on Mr. MacLeod. That means it was his job to convince the judge. He didn't have to prove his case beyond a reasonable doubt, like in a criminal trial, but he did have to show that his side of the story was more likely true than not, even if it was just by a hair, like 51 to 49.
So after hours of testimony and wading through nearly 1,000 pages of exhibits, the administrative law judge was finally ready to make a ruling.
And the decision was incredibly clear and to the point. Mr. MacLeod's petition dismissed. The judge found he had not successfully proven that the HOA broke the law. So why? Why did the judge side with the HOA? Well, it all came down to this one powerful phrase. The judge decided that Mr. MacLeod's argument that an HOA has to go out and obtain records it doesn't have was just not a fair and sensible way to read the law. So let's break down the judge's logic. It was really built on a fundamental principle. A court's job is to interpret the law as it's written, not to start adding new rules to it. The law says make available, and the judge decided that means making available what you actually have. It doesn't magically create a new duty to go acquire documents from somebody else, like a bank. To force an HOA to do that, in the judge's own words, would stretch the law into something totally unfair and nonsensical.
Okay, so that was one specific case in Arizona, but the thinking behind this ruling has some really big implications for pretty much anyone living in a community with an HOA.
So, what can we all learn from this? Well, the biggest lesson is that in a legal fight, the exact wording is everything. This case makes it crystal clear that make available is not the same thing as go and get. It's also a good reminder that while homeowners definitely have rights to information, those rights aren't endless. And if you think your rights have been violated, remember, the responsibility to actually prove it is probably going to fall on your shoulders. And all of this leaves us with one final big question to chew on. Is this ruling a necessary shield that protects HOAs from being buried under impossible, endless demands from residents? Or is it a loophole that could actually make it harder for homeowners to get the real financial transparency they're looking for? It's definitely something to think about.